Hi, welcome to the WYN Legal channel. This is the channel where you get tips, tactics and strategies to help you through your legal dispute. If you like what you see, please do subscribe. And today I'm delighted to be joined again by our Senior Litigation solicitor, Paul Werth, here at WYN Legal. And last week Paul spoke about letters before action and how to craft very robust ones, and today we're talking about how to draft powerful letters of response. So Paul, thank you very much for joining us again.
Pleasure. My pleasure
again. It's fantastic to have you last week on our live YouTube channel. So it can always be quite daunting when you get slapped with a letter before action, and last week you spoke to us about how to draft those powerful letters. Today we would like to speak to you about your tips and tactics for our viewers about what happens when they receive a letter like this, and how should they best go about responding formally by way of a letter of response. So what would you, in your experience, what would your tips and tactics be when you receive something like this?
Okay, well, I think first of all, start from a position of, well, what sort of letter before action have you received?
Yes.
Because broadly speaking, in my experience, there are two types. There's one written by somebody who knows what they're doing, and it's a formal, proper, protocol-compliant letter before claim, and others are a little bit more informal and not quite compliant. So it's best if you sort of try and work that out first of all, and I'll come on to protocols in a little bit.
Yes.
If you come to the conclusion that it isn't compliant, reply anyway. It's important to keep your arguments about the dispute going. But point out why it's not compliant. Don't be afraid to say to the prospective claimant, you've got this wrong. We need to deal with certain other matters. You need to deal with certain other matters before you issue any legal proceedings, because that's what this letter of claim will have said.
Yes.
Letter before claim, it will have said, this is our claim against you. If you don't respond, if you don't accept what we say, we're going to sue you. And you really shouldn't be sued until a protocol has been complied with. So I would say that first of all. Whatever it is, I mean, let's assume for the moment that it's a protocol compliant letter. Well, why go through the process? Well, it's so that the parties can best understand what the various issues are. It may help them to negotiate a resolution of any dispute. And it may also help to narrow down the issues between you, because you would have hoped that the letter before claim will say, this is our claim and this is why we're making the claim. This is, if it's money, this is what that's all about. And it gives you a chance, maybe you'll agree with some of it, but not all of it. Yes. And so this process of having a proper formal response is there to address all of those matters. I've mentioned protocols, which I've mentioned to you.
What do our viewers need to know about protocols?
Well, before any claim is issued in the civil courts in this country, courts expect people to comply with the magical protocols for the reasons I've just given. Help to negotiate, narrow down the issues and so on. Do everything you possibly can before the case gets to court, and as a potential defendant, responding to a letter before claim, you want to do everything you can as well to try and avoid being sued. That's not always possible. No. But if you can draft a robust response, that may push the prospective claimant back, and he may give pause for thought. Protocols, well, there are a lot of specialist protocols. If you were to Google CPR, standing for Civil Procedural Protocols, you would hopefully be directed to a Department of Justice website, and that will be headed CPR protocols, and it will then have a menu of about 18, I think it is at the moment, different specialisations. Might range from construction disputes, business debts that are owed, repairing disputes on residential or commercial property, and various other things as well. There is amongst those, if you look, it's the second one down on the list, oddly, it is a sort of catch-all protocol, a practice direction for pre-action protocols. And that covers any more generalised case not caught by one of these specialist protocols. It may be a relatively simple contract claim, for example, or even a commercial contract claim, which is not one of the specialist areas. And that will set out what both sides are to do before the case comes to to fruition before claimant issues a claim. And so far as the defendant is concerned, a potential defendant, you've received your letter before action, you will have a certain period of time in which to respond. The letter before action, you would expect it to say, you've got X period of time, 14 days in the simplest of cases, 3 months in the more difficult cases, or anywhere in between. Now, one of the things you'll want to do when you pick up one of these letters, after you've picked yourself up from the floor, is you'll want to think to yourself, well, how long really am I going to need to reply to this? Is the period of time that the writer of the letter before action has set, is it realistic? Am I about to go on holiday? Do I need to interview several witnesses? Do I need to dig out old files? How long really is it going to take? And if you take a realistic view, but it's going to take you longer than expected in the letter before action, immediately ask for more time and explain why you need more time, and make it absolutely plain that if the other side were to issue proceedings before you've had a reasonable chance to respond, you'll make sure that if it comes to it at trial or at the end of trial where cost arguments are being fought over, that you'll raise that correspondence with the court. It's very helpful to lay down a paper trail for all of these matters. So you might need some more time or not. Obviously start working on it just as quickly as you can. If you can comply with the time period, so much the better, if it's realistic. When you come to draft your letter in response, you need generally to explain why it is, it may be obvious, but why you don't agree with what's said in the letter for action. If it's a claim for money, I don't owe the money because, and you'll need to set all of that out. You'll need to think about whether you might have a counterclaim. And if you do, your letter in response is now partly a letter before action in itself, and you should comply with your protocol in relation to your counterclaim. For some reason, it may well be that your opponent owes you some money, or you have some remedy against them. Set that out also.
And Paul, when you draft these letters, do you have a technique that you follow? For example, do you work in any systematic order, paragraph by paragraph, or what's your kind of methodology?
Well, a little more micromanaged than that in a way. Just as with a letter before action, almost before you, I was going to say pick up your pen or at least open your laptop, get your documents in order. Whatever documents you have, whatever documents maybe would have been enclosed with a letter before action, get them all together, get them in date order, prepare a chronology. If there have been discussions about the dispute, have notes about those when they took place, put them within the chronology. So you've got documents, anything spoken about all together, so you know where you're going. And then, really not just paragraph by paragraph, but I would say line by line. Go through the letter before action. See what response you have to each line and answer it. If you agree with anything that's said, agree. If you don't, explain why not. And it's sometimes helpful, I think, to number your paragraphs. You might find that that's the case in the letter before action, in which case try and respond similarly in terms of your numbering. Maybe you'll have sub-clauses, so if the other side starts paragraph number 1, you reply paragraph number 1. But if you've got 10 points, A, B, C, D up to J, so it's written in a coherent and logical way. And I think that's really what you need to do. If you've got documents that you want to refer to them, enclose them with your letter before claim. You might also find that whether by accident or design, your opponent has left out certain points in their letter before claim which you might think are relevant. Put them in. If they sort of follow logically on from certain points in the letter before claim, put them in there. If they don't, there might be some catch-all provisions in a contract, for example, that you might want to include, and you say, well, you might say, well, it's fine you said all of this, potential claimant, but you've forgotten about this, and you may put that sort of nearer of the end. Make sure it all goes in, however. And you also want to address the possibility of settling the case. It rather depends on where you are at the end of your letter. If you're able to prepare a very robust response, which in your mind completely kicks out the claim, you might say to the other side, well, obviously you'll want to consider all of this. I might want to keep open, a way to negotiate with you, but at the moment, chaps, we don't think we've got anything to negotiate with. We think your claim simply doesn't work, and see what they say. On the other hand, many, if not most cases, they have some grey area. It just depends. I mean, there might be a verbal as opposed to a written contract, which may, I said this, no, you didn't, and so on. It might be greyer. And therefore, although you're going to put your case robustly and strongly in your reply, in your letter of reply, you might still say to the other side, because they ought to have invited you to consider a way of settling it, look, we're open to a discussion. We're open to without prejudice discussions, so that if we come to trial, the court won't hear about it. We might be open to a meeting without prejudice. We might even be open to a mediation where somebody neutral will try and broker a deal between us. So always have that in mind. The courts do expect both parties to try and reach agreement if they can.
And do you have a preferred method yourself, whether you go down the negotiation route or the mediation route? Or
I think it really kind of depends on what the dispute is and what your response to it is. I think sometimes, if the case isn't 100% watertight on either side, I think you're better off with mediation, and particularly, cases often involve strong personalities on both sides who are often very reluctant to give way on anything. My experience is that an expert mediator, and there are plenty around, someone senior who is prepared to shake you metaphorically by the scruff of the neck and say, look, fellas, your case doesn't work in this way. Sometimes can be quite persuasive. Obviously, there's greater expense. So if the parties look like they're more amenable towards one another, look as if they don't really want to spend fortunes in fighting it, initially some negotiations in writing, over the phone, face to face, might sometimes be the best option. And after all, if that doesn't work, if you've not got anywhere or you've only got so far, well, you can always fall back on mediation later.
Yeah, there's always that option there.
Absolutely.
Yeah, no, that's really helpful, and thank you for being, so thorough in the approach that you take in your letters of response. I mean, for our viewers, what kind of 3 takeaways should they be bearing in mind?
Well, I would say make your letter sort of bold and firm in the language that you use. Try and avoid things like I think, I believe, this is my position.
Yes.
If you're not clear about something, you might say, well, to the best of my recollection. But I think firstly, be firm. Secondly, be truthful. There is, you will see if you look at the protocols, and certainly the general protocol, there is a warning in there these days that you cannot knowingly make a false statement in a pre-action letter, whether it's a letter for claim or reply, or in any document that you might put together which anticipates litigation. And if you do knowingly include a false statement, you could be held liable for contempt of court, which isn't very funny because number one, a court will be less disposed towards your case, I think. Perhaps more importantly, contempt of court comes with sanctions which are really criminal in nature. You might be fined. You might even be put, if it's serious enough, in prison. There's, I think I'm right in saying, a 2-year maximum sentence. So you want to be truthful. If you're doing this exercise properly, it will also help you to consider whether your defence to this potential claim is a reasonable one or not. You don't want to be fighting losing battles. And I would say that as well. I think my final takeaway is really as it would be with a letter before action. Write it knowing that a judge might look at this
Yes.
at the end of the day. You don't want to be embarrassed. You want a judge to think, here's someone sensible who's really thought about this, has done their best in responding, and whether I'm predisposed towards them in terms of winning the case or not, it may at least help when it comes to cost arguments. So be sensible, be thorough, try not to be too emotional.
Excellent advice, and thank you all very much for tuning in to listen to Paul Werth and his advice when drafting a letter of response. If you want to learn more about the work that we do, or if we can support you in drafting a letter of response, please visit our website www.wyn, that's WYN.legal. And we very much hope you can join us for our episode next week, where we'll carry on talking about the litigation process. Thank you very much for tuning in.